Hai, Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Fadrina Adila binti Zainal and my ID student is 2020607064.
Hi, my name is Nur Alia Hafina binti Masram. My matrix number is 20206045544.
Hello, Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Najdah binti Fairuz and my ID student is 2020497274.
Assalamualaikum and hi. My name is Nur Shaza binti Ghazali. My student ID is 20206273006.
Assalamualaikum. My name is Siti Hawa binti Mat Yusof. My matrix number is 2020458738. There are two parties involved in the case of Blue Ocean Biotech Sdn Bhd versus Pengarah Tanah Galian dan Daerah. The first party are Encik Zulkifli Zabidin, Ms. Kumar Jaspal-Kowah, and Aisha as the plaintiff that applied a toll for a piece of land for agriculture purpose, namely fish farming. The plaintiff subsequently applied for a lease of 99 years, but the application was rejected by the state authority. The state authority cancelled the toll and transferred the land to the third defendant. As a result, the plaintiff's toll was not renewed the following year. For the first and second defendant, Mr. Teo Chin Chong as a state legal advisor Perak, meanwhile Mr. Justin Divakumar, Ms. Wan and Wan as a third defendant. State authority had transferred the land to the defendant for a fishing breeding factory purpose. The defendant applied to strike out the plaintiff's claim under Order 18, Rule 19, Subsection 1, A, B, C, or D of the Rules of Court 2012. The defendant further claimed that the plaintiff's action was obviously unsustainable in law.
Okay, so the facts of the case is the state authority gave the plaintiff a temporary occupation license under Section 65 Subsection 1 Subsection A of the National Land Code 1965 for agriculture purpose, which is fish farming. Located at wilayah Mukim Pekayon Baru Daerah Majong for the land area of 12.140 hectares. So the first defendants informed to the plaintiff that the license have been approved on 13 April 2010. The letter contains the provision of the plaintiff, and the plaintiff accepts the provision without any controversy. Then the plaintiff asked to make lease on that land for 99 years, but the state authority refused it. Okay, then on 10 October 2010, the state authority cancelled the toll and transferred the land to the third defendant for purpose of fish breeding factory site. So because of that, the plaintiff not renew the toll and feels aggrieved on the action taken and claim that a declaration the alienation of the said land by the first defendant to the third defendant was invalid and against of the law. And second, he claimed that a declaration that the third defendant had wrongly accepted the said alienation from the defendants. And the third, a declaration that the plaintiff is entitled of the said land. And fourth, a declaration of the toll is cancelled, is revived and reinstated. Then an injunction to prevent the defendant from leasing or charging the said land. Then the special damages for cost of infrastructure. Then a special damage concerning the grant obtained by the plaintiff for their project. And then loss of profit because of cancelling project, and lastly general damage. The defendant also take their action as then the defendant defends themselves of the plaintiff claim under Order 18 Rules 19 Subsection A, Subsection B, C, and D, which is A is the amended right of summons and amended statement of claim dates on 18 April 2017 did not disclose a reasonable cause of action against the defendant in this action. And subsection B is the plaintiff contravened 0.53 ROC since the decision of the state authority in cancelling the plaintiff approval for toll can be only challenged in court by way of judicial review. Hence, the plaintiff action was an abuse for court process. And subsection C is the plaintiff claims against the defendants were caught by limitation under the Public Authority Protection Act 1948. Law and Order 18 Rule 19. In every process that the court may cancel or charge in any pleading or endorsement in the writing in action of any pleading and endorsement based on first, it discloses no reasonable cause of action or defenses as the case may be, and the second, it is scandalous, frivolous, and vexatious or obviously unsustainable. And the third one is it may prejudice, embarrass, or delay the fair trial of the action. And the lastly is it is otherwise an abuse of the process of the court.
Okay, for the next part, which is plaintiff arguments. For the first issue, the plaintiff state that their position was neither plain and obvious nor obviously unsustainable. The plaintiff refer the offside cases of Bandar Budi Sendirian Berhad and OSV United Malaya Banking Corporation Berhad 1993 for CRJ7 and Seruan Gemilang Makmur Sendirian Berhad v Kerajaan Negeri Pahang Darul Makmur and Arno 2016 3 CRJ1 India written submission. The plaintiff further claimed that the defendant's action had resulted in them having a reasonable expectation then the TOL would be renewed for 5 years in a row. The next part, the plaintiff contended that their action was outside the scope of 053 of the ROC and the time frame connected to it on the second issue of mode of commencement. To support these arguments, the plaintiff claimed that the claims against the defendants was based on private law rather than public law. The plaintiff then claimed that Section 67 of the NRC allows only TOL to be issued once a year. According to the letter, the state authorities had allowed the TOL to be extended for another 5 years in this situation. As a result, the granting of TOL in those circumstances moved the subject away from public law into the domain of private law. The plaintiff argued that simply because the action include a public body, it did not follow that the mode of commencement must be one under 053. Finally, the plaintiff claimed that they had requested for declaratory orders on the issue of the plaintiff action being prohibited by limitation due to Section 2A of the PAPA, which is the suit, action, prosecution or proceeding shall not lie or be instituted unless it commenced within 36 months next after the act, neglect or default complaint or in the case of a continuance of injury or damage within 36 months next after the causing therefore. As a result, the limitation period had no bearing on the action. The plaintiff relied on the Court of Appeal case of Belar Jabu and OSV Merawa Senior Berhad and ORS 2011 for CRJ 751 to back up his claim.
Now, I would like to explain about defendant argument. As the first issue, defendant argued that plaintiff's state letter of toll were made of literal rule just to avoid ambiguity. Later, the toll was set by the rule as on the NLC. However, the defendants still argue about the acceptance of toll by the plaintiff as they never complained. they need to consider more about the provision that enabled by SA before they start to go deeper about the provision of toll. Defendants still have an objection to the SA as they let the plaintiff to take up the land for certain purpose that is stated on the license. However, SA could terminate any time if the plaintiff violated the terms. Furthermore, defendants still argue that SA has right to reject the license that involved to the land. They continued the agreement as they said the plaintiff's statement of the claim was not reasonable to any action they do to the land. Also, they argued that SA is a public authority, so they must continue to use judicial review under Order 53 of the ROC. Later, the toll was terminated as the plaintiff abused the process of the court. On the third issue, plaintiff was caught doing illegal doings. They already notified the plaintiff about the cancellation of toll. However, they still continue the process to the land. After 4 years, 4 months of cancellation of toll to the plaintiff, finally on 27 February 2017, the writ of summons and the statement of were filed based on the plaintiff action that time. The plaintiff claims must be cancelled as the defendant keep pursuit. That's all from me. Thank you.
So for the last part, there is the court decision. So for the first court decision is the court cannot accept the plaintiff action because the state authority can be anytime declined to renew the toll if for any reason and the government requires to take the land back. Second decision is can I agree with the defendant argument that the plaintiff should have proceed by judicial review under Order 53 ROC because the plaintiff had made use of the land for commercial purpose and relationship between the plaintiff and the state authority leans more toward a contractual relationship. Also, the plaintiff claim is monetary in nature rather than substantive right. So for number 3, court decide to award first and second defendant RM1,000 ringgit, and a court allow defendant to cancel plaintiff claim because plaintiff written statement of claim does not disclose a reasonable cause of action, and the plaintiff's claim is an abuse of the process of the court and frivolous and scandalous also limitation period. That's all for me. Thank you.